All right, thank you all. We're excited for our next part of the conference, which is our only bigger panel of the day. And we're talking about oil and gas with this panel. And so we've got a number of notable speakers who are joining us. And the panel is moderated by my friend, Affie Ellis, who's a shareholder at Brownstein and is also a Wyoming state senator representing Wyoming Senate District 8. Senator Ellis is a respected advisor on federal Indian law and policy. She's a member of the Navajo Nation and serves on the Navajo Nation Gaming Enterprises Board of Directors. She also counsels clients on public lands and natural resources, regulatory and administrative affairs. And in doing so, she draws from her experience as an assistant attorney general for the state of Wyoming, where she litigated cases involving the National Environmental Policy Act, the Endangered Species Act, the National Forest Management Act, and the Federal Lands Policy and Management Act. Senator Ellis has taught federal Indian law at the University of Wyoming as an adjunct professor and served on the Commission of the U.S. Tribal Law and Order. Where she developed a comprehensive study of law enforcement and criminal jurisdiction of Indian country. She's testified before the U.S. House of Representatives and Senate committees on the Commission's works and findings and submitted her recommendation in the Commission's recommendations to Congress in 1994. So with that, I'll turn it over to Senator Ellis's very capable hands to moderate this wonderful oil and gas panel. So thank you for joining us.
Morning. There we go. Thank you, Temple, for that really kind introduction, and good to see so many friendly faces in the audience. Today, we're having a wonderful discussion, and we've got some terrific panelists that I get the pleasure of getting to introduce. The way we'll lay this out is I will introduce each of our panelists and then leave them with a chunk of time where they can explain some of their thoughts and perceptions on how energy law and policy is moving in our country. And then we'll go through some questions, and then we'll leave time at the end for some audience questions and participation as well. So with that, to my right, I want to introduce Malinda Morain. She is a shareholder with Beatty and Wozniak. Malinda joined her firm in October of 2013, and she focuses her practice primarily on oil and gas litigation and federal lands. Malinda is a zealous industry advocate for those of you who have worked with her and know her inside the courtroom and before administrative agencies. She regularly advocates for clients on matters related to natural resource development on public lands, as well as environmental issues. Malinda has experience with contract and land use disputes, as well as royalty and payment proceeds litigation. Malinda has extensive experience in state and federal courts at the appellate level. She takes a thoughtful and efficient approach to litigation and has experience in complex multi-party disputes and large-scale electronic discovery. Prior to joining Beatty and Wozniak, Malinda worked in the New York office of an international law firm where she represented an industry joint defense group, as well as a leading petroleum company in a complex multi-district environmental and products liability litigation. She also worked as a law clerk with the staff attorney's office at the United States Court of Appeals for the Second Circuit and a summer associate in an intellectual property and litigation at a top firm in her hometown of Iowa. So Malinda, look forward to hearing your comments. To Malinda's right is Sam Kalen, who is the William T. Schwartz Distinguished Professor of Law and the co-director for Law and Energy Resources in the Rockies. Professor Kalen joined the University of Wyoming College of Law faculty in 2009. He is an expert in energy, public lands, and natural resources, as well as environmental and administrative law. He founded and is now the co-director of the Center for Law and Energy Resources in the Rockies. Prior to joining the College of Law, he held various adjunct and visiting teaching positions at the University of Baltimore, Florida State University, Washington and Lee University, and Penn State. Professor Kalen practiced in Washington, D.C. for more than 20 years, both in the private and public sectors. His private practice work focused on energy, environment, as well as public lands and natural resource law, and he worked primarily on those issues when serving in the Solicitor's office at the Department of Interior during the Clinton administration. And then finally, we have Phil Lowe, who is an attorney with the United States Department of the Interior. He's an advisor within the Interior's Rocky Mountain Regional Solicitor's Office. He's formerly a hydrologist and environmental scientist in the environmental management and licensing section of a major electrical utility. And he was also an attorney in the environmental practice groups at two large firms in San Francisco and Denver. At the Regional Solicitor's Office, he advises interior agencies and clients on legal and policy matters related to public land and minerals management, and he has extensive litigation experience before the Interior Board of Land Appeals and federal courts. Phil advises the BLM clients, his BLM clients on NEPA and FLIPMA issues associated with environmental impact statements and environmental assessments on a variety of land planning actions and project level records decisions. He is a board member with the Foundation for Energy and Natural Resource Law and has a 1981 Bachelor of Science with honors from Rutgers University, where he won several athletic and academic awards, and a 1989 Juris Doctorate from the University of Texas at Austin. So with that, we're going to have a wonderful discussion, and I'll hand the mic over to Malinda, who will give us a presentation.
All right, thank you. There we go. We'll see if we can work this. So I'll be speaking a little bit today about BLM's oil and gas leasing policy. You may wonder why me, a lawyer in private practice, is speaking about BLM's current oil and gas leasing policy when there are obviously much more qualified people to speak on that today who are in this room. I have actually been involved in a lot of the litigation that was discussed in our first panel, NEPA litigation and other things that has impacted policy going forward. So I'll be speaking from that perspective today. Maybe. Oh, now I'm doing things. Is it the forward backward? Yep. Okay, there we go. First of all, we're lawyers here, so disclaimer, these I'm speaking on cases I've litigated before. Obviously, these are all my opinions, not my clients. Also, I'm solely responsible for the cheesy GIFs that you'll be seeing today. So again, I discussed why I'm doing this as opposed to somebody else. I have been involved in a lot of this litigation that we talked about. So moving on to, where am I pointing this? There we go. Where are we going today in my talk? First, we're going to do a little background, just cover the areas of law that that we need to kind of focus on to understand these cases. To quick background on the federal oil and gas leasing program, a few example cases, and then the last piece will be what now and where do we stand today. All right, so I'm sure we're all familiar with these laws, but just going to address them as to how they affect the cases I'm discussing today. The APA is kind of the basis for getting into federal court on these cases. NEPA, FLIPMA, all of those do not have private rights of action. So they all have to be brought kind of on the APA umbrella. National Environmental Policy Act. Interestingly, one of my colleagues pointed out that in not a case I'm discussing today, but the DAPL pipeline litigation, this was referred to by the court as the National Environmental Protection Act, which may indicate, the result in that case. FLIPMA, Federal Land Policy and Management Act, for our purposes today, the important provision is that all land use decisions have to be consistent with the land use plans that are in effect. Mineral Leasing Act kind of goes to the last bit of litigation I'll be talking to today that imposes, the requirement that we hold regular oil and gas lease sales where such lands are available. And last, the Endangered Species Act, not talking about that in any of my cases today, but this list wouldn't be complete. And talking about leasing sale litigation would not be complete without addressing that. All right, so on to the oil and gas leasing program. We talk about this in kind of three phases: the land use planning phase, kind of the broadest land use plan; leasing stage, which is the second one where we actually offer oil and gas parcels for lease; and the site-specific development or APD level case. The important thing to think about today is that each of these stages constitute a final agency action going back to the APA. Basically, we'll see lawsuits at every single one of these phases. Oh, I did it again, sorry. There we go. In addition to that, there are also have been lawsuits brought based on various guidance documents, executive orders, as well as regulatory updates that can also serve as a point of litigation for BLM. All right, so let's jump into the actual cases. The first group of these cases I call the NEPA sufficiency cases. It's where plaintiffs are challenging whether or not BLM took enough of a hard look at the environmental effects of its decision. So the first group of cases are the greenhouse gas cases. There were 3 related cases in the District of DC, and 2 decisions that came out of that specifically related to all of the oil and gas leases offered in the state of Wyoming in 2016 and 2017. So the basis was that BLM had not taken a quote enough hard look at the direct, indirect, and cumulative effects of greenhouse gases. And the DC District Court found in 2 different decisions, both on the initial greenhouse gas analysis and the supplemental one, that there were deficiencies in BLM's analysis. So now going forward, BLM has to take into account not only its own rules and regulations and how it does these NEPA analysis, it also has to take into effect the court's opinion in the district court as to what they did sufficiently or not sufficiently. Now, interestingly enough, in a separate case in the District of New Mexico, the judge in that case, looking at later leases were offered, found that the greenhouse gas analysis was sufficient. So I don't envy BLM in trying to make a determination of going forward how they're going to do that analysis in light of kind of these competing decisions. All right, similar in the FLPMA cases, there were kind of 2 sets. You'll notice a theme here, by the way. None of these cases were actually brought, although litigating over Wyoming leases, in the District of Wyoming. The first of these cases, Montana Wildlife Federation versus Holland. It involved, we heard discussion this morning about greater sage grouse. It involved a provision of the resource management plan for greater sage grouse that set an objective to prioritize leasing outside of greater sage grouse habitat. That 1 or 2 sentences in the sage grouse plan in, I think, the March, what was going to be the first quarter 2021, resulted in 22 pages of prioritization analysis to try and comply with this decision that found that the prioritization analysis in the previous cases was not done sufficiently. Similarly, in the Western Watershed Project v. Zinke, that related to FLPMA and NEPA provisions regarding public comment periods. So they put out the draft EA, BLM provides for a public comment period. They put out the final decision, BLM provides for a protest period for the public to respond to what they see as deficiencies or anything in the EA. And the court found in that instance that that was not a sufficient period that BLM provided. So now BLM, even just these 3 cases, has multiple decisions on which they have to factor in to issuing EAs going forward in the future. And again, we do have competing results. A district court in New Mexico looking at different leases offered in New Mexico found that that public comment period, which didn't necessarily differ from the others, was sufficient. So that's the position that BLM's in today. Again, I don't speak for BLM here, but this is what I assume was their reaction to getting these competing decisions. All right, so where has BLM gone from that? We had Executive Order 13990 that was issued by the current administration saying, we got the message on greenhouse gases, we're going to do a better job of, doing that, and issued an executive order kind of setting out some guidelines as to how they were going to, among other things, calculate the social cost of carbon of some of these leasing decisions. Of course, not surprisingly, BLM was then sued, or the administration was sued for for this executive order. I won't go into today whether any of these particular decisions were final agency action. But again, we had 2 different results. In the Missouri v. Biden case, the court dismissed the state's challenge and said the executive order could stand effectively. In the Louisiana v. Biden case, the court denied dismissal and issued a preliminary injunction preventing the administration from implementing some of these numbers in their NEPA analysis going forward. At which point DOJ just announced that, they had already used, because of course, all of these NEPA analysis are continuing. They'd already used these numbers and would just have to kind of shut down the NEPA analysis on the projects while they figured it out. Eventually that injunction was stayed by the Fifth Circuit. But again, we have competing lawsuits, competing results, and BLM has to navigate all of this when continuing to issue new NEPA analyses for the ongoing lease sales. And I don't have to cover the Inflation Reduction Act because luckily it was covered this morning by the Deputy Secretary. But essentially the important provision in the Inflation Reduction Act for us is that 6-month timeline by which you cannot issue right-of-way permits for renewable development unless we are doing those lease sales. So now in addition to having kind of this competing case law on how to do the EAs going forward for the lease sales, we now have a deadline. All right. So, this is kind of where the industry sits here. Now, but this problem, as we discussed this morning, is not going away. There will continue to be kind of substantive challenges brought through NEPA and FLIPMO while we have sequential quarterly or, regular lease sales going forward. And in short, I don't envy BLM in the position that they are in as to conduct these such that they will be defensible going forward. And I think we're going to reserve questions to the end, but got to use this slide. So
Thank you, Malinda. Now we'll hear from Sam.
Maybe you can hear from me. There it goes. Well, thank you, everybody. And thank you for inviting me. I probably need that thing. So yes.
you don't want me driving.
Well, let's be clear. These things are really complicated. I don't even use them in my classroom. I use my own because this thing does not work well. So it's a relation. It really relates to this. So see, so thanks everyone. So, I'm just going to really give you more of a 10,000 foot highlight, but we can start at least for the last couple of years. And I'm going to be talking about the natural gas industry. It has become the focus of sort of numerous conversations. We've been talking about it first as a bridge fuel, and now maybe after the war with Ukraine and the difficulty of getting more natural gas into obviously Europe. It's had taken on a different meaning and different types of conversations, particularly even as President Biden indicated that he wanted to increase exports to about 50 billion cubic tons through 2030. And so we're going to have a number of continuing conversations about how to really achieve what President Biden is really going for. And so that takes me to a really convoluted slide. And my effort here is to try to illustrate that when we talk about what we're going to be doing with respect to natural gas, and particularly as well in relationship to climate change, it's really complicated. You've got so many different factors that are coming into play to try to affect the natural gas industry. And, to do it justice, if I was trying to predict and project, if you will, where the industry is going to go, what's going to happen, whether we're going to be able to make President Biden's objective basically within less than 10 years, take a look at all those different elements that are going into them. And those are only the ones that I quickly came up with. There's a lot there that I could probably add if I had more time. And I'm only going to talk about a few of those today, but it really does give you a sense about the difficulties confronting the natural gas industry today, because you have all these different overlapping regulatory regimes, different jurisdictional entities that have control or regulatory control over the natural gas industry. And then you have changing markets, changing technologies that are also as well influencing what's going to happen with respect to natural gas. So let's sort of begin to take a look at just a few of the issues that I want to cover today. I'm probably going to just focus on briefly what the Environmental Protection Agency has done, how that might influence the future. Secondly, then, what the Federal Energy Regulatory Commission has done. Then I'm going to go talk a little bit about the other things that we haven't heard with respect to the Inflation Reduction Act. And then I'll probably end with a sort of a discussion of what almost happened in terms of permitting reform that Shannon sort of alluded to at the beginning of the talk today. And then where I think the future might be in terms of, are we going to see some reform and what might those issues be by the end of this year? So my goal is to sort of give folks partly an update of what's been happening with the industry, if you will, then since the last time we were gathered for this conference. So let's start first with the Federal Energy Regulatory Commission. And as we all know, and we heard Shannon talk about this with respect to hydrogen, you know, the commission has jurisdiction under the NGA over the natural gas interstate pipeline industry. And there have been a lot of questions in the last, I would say, at least decade about what we're going to be doing in terms of promoting natural gas. What are the issues that the commission has been confronting? And basically, the commission's been operating under 1999 policies. And those policies govern a couple, I would say, major issues about how the commission looks at permitting under Section 7 natural gas pipelines. One is, what kind of return on equity will natural gas pipelines get? Effectively, how much profit are they going to be able to make? The second thing is, how should the commission be able to make an assessment about whether or not there's a market need for natural gas, whether they should be able to look at what we call precedent agreements by shippers that illustrate a market need. And then the third thing that sort of animated the commission as well in the last several years has been, how should the commission address greenhouse gas emissions that are somewhat associated with a decision to approve a new natural gas pipeline? And so with that, I wanted to take a look at basically two cases and then something related to another agency, and that's on PHMSA. So the process that the commission basically has used in the past, as I said, to assume whether or not they should have a market need, addresses the use in the Oberlin case, addresses the use of market need. So if you have to have a need for natural gas, how do you demonstrate that need? Well, you basically have an open season where folks come in and say, yeah, I want to have natural gas. I will effectively be a shipper on your line. And so in the Oberlin case, what happened there was, what happens if the major precedent and agreement is for exporting the natural gas to Canada? Is that a market need here in the United States? Should we be able to say that, oh, okay, we're going to allow new natural gas pipelines for export to another nation? And initially, this case, when it went through the courts said FERC did not do its job very well in terms of adequately explaining whether or not market need to effectively export natural gas was going to be able to justify issuing a certificate under the NGA. So they sent it back down to the commission. The commission once again said, yeah, that's fine. Goes back up to the Court of Appeals. And this time, and this to me is somewhat of an important case, it was decided in the summer of this year by the DC Circuit. And what it said is, yes, you can rely upon a precedent agreement that is basically for the export of natural gas to another country. And so if you think back to what President Biden's talking about with respect to LNG exports going over to Europe, this was an important decision to be able to say that we can really have and rely on those kind of precedent agreements. The next case was this sort of, if you will, the Delaware River Keepers case. And that involved the Adelphi Gateway project. And in Delaware Rivers Keepers was concerned with this particular project. It really was only a few short laterals and a compressor station. And the Federal Energy Regulatory Commission's environmental assessment there acknowledged that it would increase greenhouse gas emissions, but it said that it could calculate it really couldn't calculate the effects because they were not reasonably foreseeable, and particularly the upstream impacts because the fact that where the gas would go, they might have no way of knowing. and they'd have no way of knowing where the gas would go. They would have no way of knowing whether or not, in terms of upstream, whether or not more natural gas wells would be drilled. So what they said is, we can't really easily figure out both the upstream impacts, i.e., will more wells be drilled? Is this going to just be gas from other pipelines? So they couldn't figure out what those associated greenhouse gas emissions would be. They also couldn't figure out easily what the downstream greenhouse gas emissions would be, because they had no idea where the gas was going to go. They really didn't have any understanding of this agreement that the pipeline had for where that gas would go. And they really didn't ask the pipeline any questions about where that gas would go. So they said that those impacts were not reasonably foreseeable either. The reason this is all important is because up until the Delaware case this August, most of the recent cases out of the Court of Appeals that related to FERC's treatment of greenhouse gas emissions were basically telling FERC, you're not doing your job. You have to analyze better the greenhouse gas emissions from a decision to certificate of pipeline. But this time, what the commission did is it said and explained why it couldn't easily calculate some of those emissions, because they were not, quote unquote, reasonably foreseeable. And the court upheld that. So it's the first major case that really upheld the Federal Energy Regulatory Commission's sort of modern approach toward taking a look at greenhouse gas emissions. So let's go then to, there's a sort of another issue that's sort of percolating at FERC, and that is related to the use of how we look at, in terms of environmental documents, environmental justice. And it's beginning to creep into now the Federal Energy Regulatory Commission's concerns with respect to pipeline certification. And we all know this is one of President Biden's administration's top initiative. So in a recent environmental impact statement for an LNG in the Gulf of Mexico off the Louisiana coast, the environmental impact statement there reviewed the environmental justice issues presented by a Commonwealth LNG project, which would export to an Australian company about 1.18 billion cubic feet of gas per day. While the EIS concluded that the project would not likely disproportionately impact environmental justice communities, the project, along with other projects, would cumulatively have an adverse effect on low-income and minority populations, particularly local fishermen. This is the only EIS, and this is basically what I would say is the only EIS staff or FERC EIS where the staff said, we recognize that there is an environmental justice issue, that there is a problem with the pipeline, and we don't think that we can fix it. And that's important because in the past, when the FERC has basically had its staff address environmental justice issues, it's basically said, we think we can mitigate against those issues, and therefore it's gone forward. In this particular instance, the staff said, we don't think we can, that the cumulative impacts that are going to be flowing from this LNG project are going to rise to too much of a level for environmental justice concerns, and that we don't think that it'll go forward. What the commission will do, we have no idea, but this is one of the first times we've seen that, and we'll see how that plays out in the future. And that dovetails to another agency that's also going to be addressing environmental justice issues, and that's the PHMSA, which regulates for safety hazardous pipelines. They just had a final rule this August on gas transmission. And this has been a decade in the making. And this final rule, which was first initiated in 2011, it concludes a trio of pipeline safety rules. And it's basically now addressing, if you will, more than 400,000 miles of previously unregulated gas gathering lines. It's going to, according to the agency, strengthen the safety and environmental protection on more than 300,000 miles of onshore gas transmission pipelines to the U.S. And it it has a number of other sort of requirements. It's going to impose, for example, new management change process requirements for pipelines. It's going to strengthen integrity management requirements. It's going to bolster corrosion control standards. It's going to institute new requirements for inspection and things like that. The other thing, though, that just happened this week at the meeting of the Energy Bar Association is that the agency announced this week that it also hopes to finalize and update rules for CO2 pipelines. Hopefully, they said reportedly in the next couple of months, and it's now working on a proposed rule for methane emissions. So let's take a look at methane. Many of you already know or may know that the Environmental Protection Agency last November issued a rule that is designed to sort of address, if you will, methane emissions. And the idea and the concern about methane emissions is, I would say, captivating a lot of discussions today. In a report last week about gathering pipelines in the Permian Basin, they are reportedly releasing methane, at least more than we had ever thought. There was obviously the report about Nord Stream and how much methane emissions from Nord Stream. There was a September report in Science that gas flaring might produce about 5 times more methane than originally thought. And then we had a report earlier this year from NOAA that methane emissions in 2021 were the highest since they were first started to be reported in 1983, with methane emissions in 2021 reportedly at about 640 million tons. Even President Biden's July 12, 2022 statement with Mexican president committed to tackle methane emissions from oil and gas and other sectors, building off the global methane pledge from 2021's COP26 in Glasgow. And then starting, therefore, in November of last year, EPA issued this proposed rule targeting the regulation of new and existing air emission sources at oil and gas wells, gathering systems, and compressor stations, as well as natural gas processing plants and transmission and storage facilities. The agency hoped that it would reduce methane emissions by roughly 41 million tons through 2035, or about 250 million equivalent tons of CO2. This would be about a 74% reduction from 2005 emissions, and it would spur recovering about $690 million in value in 2030, for instance, that might otherwise go to waste. Then in April of this year, the Government Accountability Office released a widespread report entitled Federal Actions Needed to Address Methane Emissions from the Oil and Gas Development. And as many of you may recall, both BLM and EPA both issued regulations a long time ago, or at least several years ago, targeting reduction of methane emissions. I'm sure Phil remembers what happened to BLM's role, and we all here don't need to go into that. And the same thing happened to obviously EPA's role. But the important thing is EPA has indicated that it is supposed to issue a supplemental rule to its proposed November rule. The likelihood is that EPA will do something to update this rule after the midterms. That's just my projection, only because of the government not wanting to do things before the election. So we'll have to see what happens there. So now let's go on to the Inflation Reduction Act. We've heard a little bit about that, and I'll try to be somewhat quick. You know, folks can figure all this out when you look at it. So at sort of a 10,000-foot level on the IRA, it has a number of provisions, such as mandating certain offshore leases, as well as we already heard, tying onshore and offshore renewables to making available for leasing a certain amount of fossil fuel resources. But it also increased the offshore royalty rate for 10 years from 12.5% to 16 2/3%, and not more than 18 3/4%. It similarly increased the royalty rate for onshore, something that at least a lot of folks who've been sort of writing about this for a while have sort of discussed. It also changes the minimum bid for onshore from $2 to $10 an acre in 2 years for the next 10 years. It also changed rental rates. And the one thing it did, interestingly, is it was also required the secretary to assess an expression of interest and leasing land fee at basically $5 an acre, adjusted every 4 years. And not that folks care about those in the academy, but we've been having a debate about whether we think this is going to have an impact or not. But for our purposes, it's also worth some time focusing on the last thing here, is that the IRA imposes, for the first time in federal law, effectively a charge or a cost for greenhouse gases. So it's a charge on methane. And so for all leases issued after the act, it directs that royalties paid for gas produced from federal land and the OCS shall be assessed on all gas produced, including all gas that's consumed or lost by venting, flaring, or negligent releases through any equipment operations. The exception is that it will not apply to gas vented or flared for not longer than 48 hours in an emergency situation that poses a danger to human health, safety, or the environment, or for gas that's used or consumed within the area of the lease unit or a communitized area. It also commits $20 million for methane monitoring under one provision, and another $850 million for methane mitigation and monitoring for grants, rebates, contracts, loans, and other activities. And not to mention, by the way, $700 million for methane mitigation from conventional wells. And then, of course, going to sort of the waste emissions charge for those who want to emit over 25,000 metric tons of CO2 equivalent. You've got a report who report under subpart W. They're going to end up paying a effective emissions charge. And I wish I could, now this isn't going to work. Each one of these categories here has a separate line within the IRA to try to really address how much they're going to be paying. So I'm not going to go through and explain how it's done. And it's really weirdly drafted, by the way. But it basically is off a threshold amount. And so, for example, the first two categories there are going to be paying off a threshold amount, a certain emissions charge that starts at $900. And then it goes up every year. And by 2026, it's about $1,500 and thereafter. So those are sort of the new and sort of interesting methane emission charges. And then you can sort of see, I guess, a little chart here that comes from a report that EPA has about what it's really talking about. These are all the ones other than around that blue circle are the ones who are going to be paying under that emissions charge. The ones in the blue, they're excluded from the methane charge because they don't report under subpart W. So now, lastly, the IRA does one additional thing. It's what I'm going to call a hammer provision. It basically says to EPA, you know that rule you had in November of 2021? If you don't do that rule, you know what? The provisions of the IRA are going to kick in. So EPA's final regulations will be effective if they become effective and they result in the equivalent or greater emissions under that would be achieved under that November 21 rule. Then that rule will be effective. Otherwise, the IRA kicks in. So it's effectively a hammer provision to make sure EPA does its rule. So then lastly, let's go to the deal that happened and the deal that didn't happen. So we all thought that what was going to happen in terms of the congressional resolution, the CR, and it was a must pass, obviously, bill, that Senator Manchin would get something in there. And the industry's discussion about what they really wanted in that deal were really revolved around those things that you can see up there. First, streamlining the NEPA process. We heard the governor this morning talking about NEPA, but streamlining the NEPA process. The second thing is that they wanted some relief under the Clean Water Act, particularly Section 401. There's been a lot of debate. We don't really have time to go into it about whether or not states have been abusing their Section 401 authority when they have the ability to decide whether or not a discharge by, let's say, an activity associated with a natural gas pipeline might violate the state's water quality standards. And some states believe that certain states have been using that authority to not worry as much about water quality standards, but rather to go after natural gas pipelines for other reasons. And so one of the ideas was to curb that sort of effort by states. And then the last thing that we saw in terms of efforts to try to get some reform was on limiting judicial review. And so those were all the sort of dialogues that happened. And then finally, there was one little sort of, I would say, added effort to all that. And that was Senator Manchin and Senator Caputo wanted to be able to get the Mountain Valley pipeline through. And the whole goal sort of driving this was to be able to say, with all the litigation that had been going on with the MVP, that the legislation would basically bless the MVP so that it would end up with having no more litigation. And by the way, there's another MVP case that's being argued very soon. And so the whole idea was to cut all that off. That didn't happen. And I think I'm running out of time, right? Oh, I'm okay. 3 minutes. Okay. Because it would be really interesting to try to at least have some conversation then, or at least some time to talk about what we think is going to happen in terms of the next effort, because obviously there had been a deal by Senator Schumer and Senator Manchin to try to solve some of the problems that the natural gas industry was experiencing on things like Mountain Valley Pipeline that had delayed the ability for the pipeline to get constructed. The pipeline now has an extension so that it can has a number of years more to be able to go through all its environmental clearances. But in terms of the deal that's been out there and the deal that they've been talking about, it really is going to revolve around, can we get some sort of streamlining provision? Can we get changes to Section 401? And interestingly enough, can we effectively limit the time frame for challenging under the basically a decision on a natural gas pipeline under the National Environmental Policy Act? And there's been a lot of dialogue about, instead of allowing a lawsuit to occur, let's say within 6 years, which is typically sometimes the statute of limitations generally, or under other statutes, to basically limit challenges to within 150 days. The other thing that they've been talking about is whether or not they can restrict a court's ability to issue an injunction against the pipeline. And then finally, if you take a look at the Energy Security Act of 2022, introduced by Senator Caputo, there are a whole bunch of other things in there, including changing the Clean Water Act and PDES permitting program. There was a provision in there that would solidify the nationwide permit for natural gas pipelines. And there was another provision in there that would effectively prohibit the use of the social cost of carbon when you analyze the greenhouse gas emissions impacts. That's not to mention a whole bunch of other things that was in that bill, but it sort of lays out, if you will, a template for what the likely dialogues are going to be between now and the end of 2022 about what we're going to, if we're going to see any sort of permitting reform. So now I think I'm out of time.
Thank you, Professor. We'll move on to our next speaker, Bill.
We need two lawyers to figure out how to use the microphone. Thank you very much to Temple, the university, the organizing group for inviting me to speak here. We all know that a continuing resolution passed because otherwise my colleagues at the BLM and the solicitor's office wouldn't be here. So I'm going to do something a little bit different. I'm going to talk about crypto mining on federal oil and gas leases. But before I do it, of course, just to prove that I am a staff attorney, I have a disclaimer. You don't see this at the deputy secretary level or the secretary level, but when you're down on the bottom of the food chain, you always make sure that what I'm telling you today is my personal opinions. It's not official policy, and it proves that I am a staff attorney. And with that, that's a picture that I pulled off the internet, and I was careful to give attribution to it. That is a crypto mining operation on a Texas oil and gas lease. So you're probably saying, what's crypto? Why are we talking about this? And we'll get there. So cryptocurrency, you've all heard of it, I'm sure, Bitcoin, right? Everybody's kids had Bitcoin at one time or another, or wish we had it. Cryptocurrency is did that slide jump on me? Sorry, we'll get it. It's a decentralized finance method using a blockchain ledger to document these transactions. What's interesting about it is that it's peer-to-peer. If I go to buy something with my credit card, there's an intermediary there who is taking that payment with the credit card company. With cryptocurrency, it's from one user to another. There's no intermediaries, and it's very secure. And the reason it's secure is that because it uses a blockchain ledger. So you're probably, and we do have some experts. I think we had one of the students I talked to last night is writing a thesis about blockchain and other. I don't see him here right now, but if he's around, I'm gonna ask him to jump in, correct me when I'm wrong. So the blockchain ledger is something that's interesting because it's essentially a transaction record of everything that has happened. And it has 4 big fields. There's a previous, what they call a hash, a previous data field that says what has happened before, all the aggregated transactions that have gone in. And then they have this piece called a nonce. If there's anything today, you say, what's a nonce? Well, a nonce is a proof of work. And it's a consensus algorithm that essentially Bitcoin uses to take a random value and validate everything that's gone in that ledger before it. That's a proof of work that says this is verified in this blockchain, so we know where it goes. And how does that work? That goes another word for you, a hash. And it's not what we had for breakfast, but a hash is essentially a value that's obtained by taking data, putting it into an algorithm, and coming up with an alphanumeric value. So what's that mean in plain English? All right, my name's Phil Lowe. I work in the solicitor's office. I have an address. I have a phone number. All of that stuff is data. I could throw that into a hash and come out with 12AQ7B56, which takes all of that data, but that unique alphanumeric signature says that's the data about Phil Lowe. All right. The thing is, to validate this, when we start to work through, it requires lots of computing power. And so I'm going to talk about Bitcoin because this was about the most popular form of cryptocurrency and how that works. So Bitcoin mining's this process that takes the validation of the blockchain. It uses the cryptographic hash, and it comes up with a solution. Well, why does anybody want to do this? Well, to learn that, we've got to talk a little bit more about Bitcoin. So there's a guy named Satoshi Nakamoto. You think that's a real name? No, nobody knows who this guy is. People say, oh yeah, I think I know who it is, whatever. But anyway, he wrote the source code back in 2009. On how this would work. And it's limited to 21 million Bitcoin. I did not do that. Are you playing with me back there? No, sorry. So let's jump back here then. Okay, so, and I apologize for that, but I'll keep my hands where you can see them. Initially, this started out, there was an initial block, and that created 50 Bitcoins. And what happened is that each subsequent transaction could create more Bitcoins by verifying what has gone before. And so as it started out, people were just using ordinary computers to do this, and it would take a long time. But there was a reward offered of more Bitcoin every time you validate the previous transactions. And so initially it started out, you do your Bitcoin validation and you'd get 50 Bitcoins for doing that. And when people talk about, has anybody heard about Bitcoin halving? Sometimes it comes up in the news, Bitcoin halved. It doesn't mean the value of a Bitcoin went in half. It meant that the reward for mining this dropped. So initially it was 50. In 2012, it went to 25. Then in 2016, 12.5. And right now you get 6.25 Bitcoin for each calculation that you can solve. And that last halving event was in 2020. And right now, of those 21 million Bitcoin that could be created, there are still about 2 million to be mined. So when this was first launched in 2009, think this is not that long ago. It was hard to find any standard pricing for it. And there weren't exchanges. We talk about stock exchanges where people can come and say, I want to buy a stock, and you have a market where you can do that. With Bitcoin, there weren't any exchanges. There wasn't a publicly traded Bitcoin forum. People would talk on internet relay chat and say, hey, I'll give you, 10,000 Bitcoins for something, and say, okay, we can work that out. So there weren't exchanges that fixed a dollar value to Bitcoin. The first one came out in late 2009. And the very first exchange was 5,050 Bitcoins, got $5.02 on PayPal. So that was the first recorded Bitcoin transaction. For the first year, Bitcoin never broke above 40 cents a Bitcoin. And the reason I'm telling you about this, because it'll become obvious, and some of you might know what the value of Bitcoin is today or what it was a year ago. And you think about these early days and you said, gosh, I wish my crystal ball was a lot better, that I could have figured this out. But you think about people with crystal balls that aren't so good. There was a programmer, a guy named Laszlo Hanyecz. I can't even pronounce his last name. It has Hanyecz. I'm going to say Hanyecz, but I'm going to call him Laszlo. Laszlo decided that in 2010, he wanted pizza. And so he put an offer out on a Bitcoin forum and said, I'll give you 10,000 Bitcoin for 2 pizza if everybody picks up on that. And it took a few days. And finally, one guy gave Laszlo 2 Papa John pizzas on May 22nd, 2010. For 10,000 Bitcoin. That was worth, at the time, it was about 40 cents a Bitcoin. So it was worth about $41. So I think he overpaid for the Papa John pizza, but put that into context of today. If he had kept those Bitcoins, that was worth, at today's standards, $200 million. That's pretty expensive pizza. And the guy who got the Bitcoin for delivering these pizzas spent it on travel and everything else before Bitcoin ever broke above $4. So he didn't make much either. Why am I telling you these stories? Because I'll get there, but Satoshi Nakamoto, the guy who originated Bitcoin code, was kind of upset with Laszlo, because Laszlo started using graphic processing units in his computer to run these algorithms, and it was much faster than everybody else. And Nakamoto thought that was kind of an unfair advantage to do that. So we've learned a little bit more about Bitcoin. All right, so the values change a lot. Last week when I was working on this, it was $20,000 a Bitcoin. Little less than a year ago, it was $67,000 Bitcoin. Remember, I told you there's already 19 million that have been created. So right now there's about $40 billion in Bitcoin at current prices that remain to be mined. And this is all about a race. It's a race to figure out how to solve these algorithms so that you can get these Bitcoin rewards until they're all mined. And so now this is going to start to make sense, because the computing power to do this is extensive. I mean, really extensive. Should I aim this anywhere or just, yeah. So yes, so it's all about energy. A Bitcoin mining unit, that computer, my oldest son lives in a house with 4 other very active computer users. They hardly ever turn their heat on, because their CPUs are screaming hot all day long. And if some of you have kids who get the latest gaming computer with the liquid cooling inside and everything else, I see Bill Beck is nodding. It takes a lot of power. But some of the Bitcoin mining units that have been developed now, they can use 41,000 kilowatt hours in a day. And I just put that into perspective. That's about as much as 1,400 homes. And if you use natural gas generators to power these things, that's a lot of gas. And so I have a picture down below, and I'm going to show you a couple of pictures of these mining units. So here's a generator and a mining unit in Colorado. The first container with the big fan is just the natural gas powered generator. Behind it, and if you could see, if I had Sam's custom laser pointer, I could point out the little container in the back. It's not so little, but that little satellite up on top, that's not so they can watch, you know, Wyoming football games on the weekends over satellite. That's a Starlink uplink to the internet using Elon Musk's Starlink system. Here's a view of an array of these. So someone has gone out and put these generators with the processing units behind. And a lot of these we talked about GPUs, which are graphics processing units. Some of these are now what they call ASICs, application specific integrated circuits. They only do one thing. They solve these puzzles and they go really fast. Here's what it looks. So this is another array. This shows the actual mining units behind the generators that are powered by natural gas on lease. So now you're saying, oh, I'm starting to understand. That's why people are doing this. Sam talked about natural gas and what's going on and reducing methane. We can take methane on lease. We can fire up these generators. We can run these really big computers that need a lot of power and make Bitcoin, and everybody will be happy. And this is just some of the connections on lease. You can see the cabling going back and forth. And then looking inside, any of you have a swamp cooler? Because air conditioning is not so big up here in Wyoming because it's a little bit cooler than down. But some people have swamp coolers for the summer, which are essentially evaporative coolers. Those blue things on the right side are all to cool this stuff down. And all the ASIC processors are on the left side there. So now I'm going to get into the stuff that really earns you CLE, right? We talked about why people want to do this. There's a lot of money at stake and everything else. Why do people want to do it on lease? So just the legal history back in the late 70s, we always had on federal oil and gas leases that you had to pay a royalty on production that was removed from the lease or sold. In 1974, the department had changed the notice to lessees that said, no, we want you to pay royalty on everything, even if you're using it on lease. And so in this case, Marathon Oil versus the secretary at that time, district court in Wyoming found no, that notice to lessees saying that you cannot beneficially use this on lease without paying a royalty, we're going to set that aside. So BLM's regulation caught up with that, and it allowed for royalty-free use of natural gas on lease for beneficial purposes. That's really important concept, beneficial purposes. I'm sorry, my finger's not calibrated to this clicker. Okay, so maybe the batteries are low on it. So under the regs right now, and you can read this slide as well as I can, but essentially there is a provision to use some of the natural gas on the lease. It can be used for operations and production purposes. A lot of times this can be flared or vented if it can't be used, and you don't have to pay a royalty on it yet. But so we look at beneficial use on the lease, and you can even take gas off the lease and then come back onto the lease, so long as you have certain written approvals from BLM for this beneficial use. And onshore order 5, I'm sure, is everybody here familiar with onshore orders? They're published in the Federal Register. I know one table where everyone's familiar with them, but they provide certain regulations for onshore oil and gas operations, and onshore order 5 provides the standards for measurement, reporting, record keeping for gas. That's really important piece of this. And just to show you why I think onshore order 5 is cool, is that it's one of the few where it really gives the folks at the Federal Register a difficulty when they started putting all these. That's a screenshot from one of the formula that are in onshore order 5, just if you need to get into it. But it basically says you've got to keep track of gas coming off your lease, even if you are venting it, if you're flaring it, or if you're using it for other stuff. And there are the onshore order references BLM's regulations on civil penalties. I'm not going to get into all of that in detail, but it's there. So we've got to measure this stuff going on. So Sam talked a little bit too about the Inflation Reduction Act and what there's certain goals for eliminating the waste of gas from leases. The venting and flaring rules they mentioned briefly that had not gone through with the change in administrations. Down to the south, the Colorado Oil and Gas Commission has a rule that went into effect last year that essentially says you can't vent, flare, waste this gas anymore without paying for it. And so it's trying to reduce this. And so now some people are saying, hey, there's gas there. I can use that gas to fire these generators and mine cryptocurrency and make a lot of money, and everybody should be happy, right? Except for before, were we paying royalty on that waste gas? No. Do we pay royalty on it now that it's being used for crypto mining? How does that work? Well, let's see. Okay. One of the other things Sam mentioned really quickly is the Inflation Reduction Act, the IRA, which has a specific provision that requires royalties for all extracted methane on the lease. So if you're producing methane, even stuff that is consumed, lost by venting, anything else, you've got to pay for that. The current version of the notice to lessees that I mentioned, the old version from the 70s that had been invalidated by a district court here in Washington, the current version talks about what's going on right now. And that maintains the status quo that beneficial use on the lease is okay. You don't have to pay royalty on it, but now we're looking at, do we have to pay royalty on stuff that might be unavoidably lost? And BLM is working on a new rulemaking. I can't give you a timeline on when that's going to happen. I don't think any of the BLM folks in the audience here can do that either, but it is under consideration. So where does that leave us? What are the issues here? How do people who want to get into this Bitcoin mining operation, how do they record what's going on? How do they obtain permission to use the facilities to put them on federal lands? Is this beneficial use under, and I see some heads shaking, no, it's probably not. How does this relate to when we look at the social cost of carbon, when we're evaluating leasing in the first place? Do we take into account that some of this gas might be used for Bitcoin mining as opposed to heating people's homes, everything else? And how do royalties accrue on this? So what's the future hold? And we want to leave time for a robust discussion about everything we've been talking about here. But one of the things is there are smart people who figured out how to do this. And there are companies that might approach a lessee and say, we have these units, we'd like to place them on your lease. But the federal government doesn't hear about that until there's some reporting that they can see, okay, now we know this is going on. And is there a separate authorization required for putting this equipment on a federal lease that is not really related to production of oil and gas from that lease? That's one question. And what if the lease is split estate where the surface is privately owned? I think that question is a little bit easier to answer in that, yes, the surface owner could decide, you know what, there's a federal lease there, but I want to put these Bitcoin mining units out there. How does this relate to off-lease operations? If we take the gas before gas goes into a pipeline, we divert some of it off lease to these Bitcoin miners. And then we have the rest of it go. How does measurement and royalty reporting take place? These are all open questions. And then finally, the ownership of these as well, because let's say, and I'm going to use a completely hypothetical situation, but let's say that you are an oil and gas lessee, you have a federal lease, and you have to vent excess gas, and you've decided that, you know what, a company has talked to me about this Bitcoin mining, and they want to put these units on my lease, and they're going to reduce the amount of gas that's out there. And so I'll work out a deal with them. But does the United States have to be part of that deal? Does the BLM have to issue a sundry notice to place these on the lease? Does BLM have to do any kind of NEPA analysis to approve that? Or does BLM get to approve it? These are all open questions. And I mean, my BLM clients will know that whenever they ask me a question, I give them a standard answer all the time. You know, it's pretty easy. What's the answer to these questions? It all depends on the specific circumstances or what's going on. So I just wanted to make sure that everyone was aware of this. And I've got my contact information up there. If you have any questions about it, I'm happy to steer you to the people who really know a lot more about it than I do. And I do see Nick in the audience there. I'm going to call you out as a student back in the corner who's writing a thesis on some of this stuff. So I think at this point, I'm going to turn it back to Affie, and we're going to start our open discussion.
All righty. Well, thank you, Phil. We'll take the next 20 minutes or so to have some questions that we hopefully can discuss up here at the panel level. I've asked the other panelists if you want to build off a question or respond to please go ahead and do so. And then around 11:45, we'll open it up to questions from the audience. But sitting at this dais, it's hard not to take off my legislative hat. And so we've heard a lot of things happening in the courts, in Congress, and then these other kind of market forces with cryptocurrency coming online. So if you were to talk to a legislator, you know, how would you synthesize all this? What could these changes mean for Wyoming, for the people working in Wyoming's oil and gas industry? What could it mean for Wyoming's revenue and economy? So with that, Malinda, do you have any thoughts?
Sure. I don't have solutions, but in terms of economy, I was looking at some of the declarations that were put in after we got these decisions. And one of these was actually in 2001. They did an analysis of the impacts of this litigation in relation to these lease sales, and just one of these decisions that vacated lease sales involved $91 million in a single challenge. And that was just in royalties. So, you know, half of that, well, 48% of that is going to, of those revenues go straight to the state of Wyoming. So, you know, it is a huge impact. Interestingly, the royalties number that we calculated on that was 21 million. That was also when gas was $25 a barrel, or oil was $25 a barrel. So obviously those are much larger in today's dollars, but it is, I mean, it is a real impact on the state of Wyoming.
Yeah, and just to add to that, so when we look at what the impact is in many of these cases, and I've been representing BLM and in several of them, along with colleagues from Washington, D.C. and headquarters and in the regional solicitor's office. We work on teams, but in most of this litigation, the state has intervened to express its concerns. And the biggest concern is that when a court decides that you didn't comply with NEPA, which is a procedural statute, does that justify completely vacating the underlying lease? And I'll take it one step further, when that lease has been subsequently developed. So it's really hard to undrill a well. We can see that if someone wanted to say, okay, we need to have an immediate injunction, but to wait and file and then subsequently go back, as Malinda said, some of these cases go from leasing decisions in 2017. Is that really the court's role? The other big piece of this is there's still a lot of uncertainty because the two decisions that Malinda mentioned in Montana and Idaho are both before the Ninth Circuit Court of Appeals right now, and we don't yet have a decision from that court, which could spell out, is vacatur of a lease the appropriate remedy? And is it appropriate to challenge leasing decisions in jurisdictions where the leases aren't located? So I think it's, we heard earlier, the governor talked about the legal playground of NEPA. I don't know, maybe it's a really rough playground. You know, it's not like the nice playground. It's the broken glass and the rusted basketball hoop. It's a rough playground for NEPA. But as long as that is the state of the law, what BLM's been doing is really working hard on ensuring that they address all of the issues that previous courts have identified, but then it becomes iterative. So the next set of litigation, you mentioned endangered species, Malinda, that we really didn't get into, but the next one is, okay, you've approved an APD in Converse County, Wyoming, but you did not look at the effects of threatened or endangered species in Hawaii. And that's a case that's going on right now. So I don't know, my answer is not perhaps definitive for the state, but it's a huge impact, but the state is making its voice known.
I'm just going to add just two things on NEPA. First, I mean, what we've seen across the board is that for the last decade, Congress and all administrations have been trying to do what we call streamline NEPA. So I think that what we've seen today is a different conversation than we would have seen 10 years ago. And when we talk about the issue in terms of certainty and what might happen in terms of vacatur, obviously it's something I've written on a lot now. I think that, you know, what we're seeing the courts do is to really make judgments now about whether or not they will vacate. And you're seeing more and more courts actually sometimes not deciding to vacate. They actually have separate they have separate remedy hearings on whether or not to vacate or not. Obviously, the Dakota Access Pipeline was a classic case where there was a vacatur and then DC Circuit was overturned. And so we're still debating a lot of that. But what we have seen as well is that same dialogue now occurring in Congress, because Congress and the industry has been really at least receptive to try to figure out whether or not there's a way to curtail the ability of courts to basically vacate some of those decisions. And I think you're right on ESA. I mean, obviously the Mountain Valley Pipeline was held up because of an ESA problem. So, yeah.
Maybe this is a good segue to ask. One of the questions that we discussed in preparing for this panel today was, and maybe this is more addressed for Malinda, but what happens when particular leases are litigated? How does that impact industry decisions or plans? Just to give, for those of you in the room who don't work on that side, a little perspective of how that impacts planning and investments that have already been made in certain asset areas.
Yeah, that's obviously a huge impact on my clients, because as Phil said, you will have leases that are already in production and have been producing for several years. And obviously companies prioritize what they think are the best assets to develop. So some of these are, 50, even 80% of an oil and gas companies producing assets are ones that are challenged in this litigation. And it's a huge problem. The governor talked this morning about, business certainty and how do you get funding for these projects. And it is a huge problem and of course of uncertainty. And, we've seen some shifting kind of out of this realm just because there is so much uncertainty. We talked about the 6-year statute of limitations. That's what's been used in all of the cases that I talked about. And so you are looking at, investing and prioritizing leases. And I get calls every day. Can we develop this lease? Should we not? And the messaging they get is obviously changes with administration. So again, I don't have answers, but it is a huge issue for companies that are developing in that space, and particularly in Wyoming, since we do have so much federal development. Those of you familiar with the sage grouse planning process, with the prioritization decision, how do you prioritize development outside of habitat in Wyoming? when Wyoming is very, very much majority habitat. So yeah, it's a huge issue. It's a problem with funding, and you know, we'll see hopefully some of these efforts to streamline both the NEPA process and BLM's continued efforts to you know, try and meet the ever higher standard of NEPA analysis.
Kind of building off that question, I'm going to put you on the spot. This is a question we haven't discussed, but you know, Malinda raises something. It's a pendulum swing depending on which administration's in office. And I don't think that the drafters of NEPA and some of those other key federal acts ever envisioned it being that way. These decisions were supposed to be scientifically driven. I am curious to see if either of our, or any of our panelists think if there's a way to stabilize some of that pendulum swing, or are we just at the whims of it depending on who's in office?
Maybe that'll work. I think that what we are actually trying to see is all administrations trying to stop that pendulum swing. So at least in terms of NEPA, I mean, obviously you just had the permitting council and they've actually beefed up the size of the permitting council, which is going to help sort of streamline, if you will, federal agency decision-making, and the same thing is building off of the FAST Act. So I think that what we have seen is a uniform effort to try to have a lot more certainty in terms of the process, regardless of whether there's an R&D in the office, because all of them sort of realize that it doesn't make a difference if you're going to have a wind project or an oil and gas. We've got to have a process fast enough even for the wind project. So we've got to have a consistent process across the board that's going to be fast enough to even allow the new infrastructure in place. At least that's what we have seen, I think, from my perspective.
And from my perspective, I would say, remember my disclaimer? Before so I do think one of the things that has happened is as administrations change, they use policy documents to try to say, here's where we want to go. A regulation is much more durable. It's subject to notice and comment rulemaking. And at least the regulated community can understand that the rules of the game are that. But I do think it's difficult when the rules of the game keep changing. And I think, as Sam said, all administrations they think that this is the correct way to go with what they put in, but we don't have durable regulations at this point. And I think an example of that could be crypto mining, where, you know, is it possible to have some regulations so that oil and gas lessees say, okay, I want to do crypto mining. Where can I look to find this? I'm going to look through NTLs. I'm going to look through onshore orders, but where is there something specific about crypto mining? And I think that's the difficulty. And it's always been that way, where technology jumps ahead or legal advances jump ahead through NEPA decisions that BLM just can't quickly react to. So I think, my perspective, I would prefer more durable regulations or even better statutes that clearly lay it out.
We've touched on this already a little bit in mentioning some cases that people are keeping an eye on. But in light of the fact that we have a new U.S. Supreme Court and several new appointments to federal and circuit courts, I am curious what oil and gas, natural resource cases you're watching and are headed to these courts, and if you have any thoughts on how these new appointees might influence resource development cases. And I'm happy to see who wants to jump in first. Maybe Sam?
It assumes I can turn this on fast enough. I mean, I think that there are a couple cases, obviously, that everyone's watching. We all heard about the Sackett case, which involves the scope of the Clean Water Act. So I think the first major issue is going to be, you know, is this Supreme Court going to, or how far, I should say, are they going to change the rules of the game with respect to the Clean Water Act? And obviously that's going to have an impact on the scope or the need for, let's say, nationwide permits for oil and gas transmission lines. So we just don't know what's going to happen. I think most folks who listen to the argument and about try to figure out what the Supreme Court's going to do have concluded that they are going to get rid of the significant nexus test. But other than that, they're not likely to go all the way back and overturn an old case from the 1980s called Riverside. So they're still going to allow regulation, but just not at probably as much as they had under the test right now, which is sort of the dominant test of significant nexus. The second major case that some folks have been looking at just was argued recently And that was the pork producers case, and that involves the Dormant Commerce Clause. And the reason that's important is there's a lot of discussion about whether or not states have the ability to engage in what we call economic protectionism measures. And that relates to energy as well, because there's a number of energy type issues where states are doing things that effectively block either the sort of the import of certain types of energy resources. And they make other decisions that affect the flow of energy across state lines. That case sort of puts at heart, I would say at heart, an aspect of the scope of the Dormant Commerce Clause. And we have no idea what the court's going to do with that right now from the questioning, I think.
And speaking of no idea, I have no idea how certain courts are going to rule. For my job, it's the most important thing is presenting the best arguments for BLM at the district court level and making sure BLM has a defensible record to go on. That said, there are certain jurisdictions and certain judges that have a perceived track record, and many of the environmental NGOs will prefer to be in those jurisdictions. And so that is why we have cases filed in Montana and Idaho that relate to oil and gas operations in Wyoming. So I just hope that the Ninth Circuit rules one way or another on the appeals that are in front of it right now from the two cases that Malinda described, because that will be one way or another, it will help us to at least get some certainty where things go.
I just want to build on one thing quick from Phil. One of the provisions that was in that didn't fly in the continuing resolution was an effort to try to take the Mountain Valley Pipeline litigation and put it into a random circuit, not the Fourth Circuit, precisely because of what Phil just said, that the Senator Manchin had been really concerned that the Fourth Circuit was an improper court to continually strike down decisions on the MVP. So he wanted it to be able to go to another circuit.
We would prefer that in my cases as well. I will give a shout out. I'm a huge Supreme Court nerd. Unfortunately, they don't seem to take up NEPA cases ever. But if you listen, law students, if you don't listen to the Advisory Opinions podcast and you like Supreme Court stuff, it's a great resource. I love listening to it. I got really excited when we actually had an EPA case last session, and I think they covered it very well. So.
Alrighty. Switching gears a little bit and talking less about litigation in courts. We have talked a lot about the Inflation Reduction Act and how it's passed. But like many of you, I've been reading it and looking at, and I do think there are some provisions that have us asking, what did they mean? So as federal agencies are going to be looking at these same words on pages, they're going to have to clarify through rulemaking. Are there critical areas in that particular law where you've identified where federal agencies will need to pay close attention during the rulemaking process?
I guess that's directed to me. I really don't know. I can say, so a concrete example, and not through rulemaking, but earlier we heard about the link between onshore oil and gas leasing and right-of-way authorizations. And BLM has recently issued a right-of-way authorization in the Desert Southwest that explicitly referenced the tie from the IRA and explained why it fits within the scope of the percentage of nominations that were leased or the acreage stuff. And that was all related to the June 2022 lease sales. So BLM's looking at it. And so if you follow any right-of-way authorizations, they're going to have a descriptive piece that explains why they are consistent with the statute, but we don't have regulations that tie that explicitly yet. So BLM's doing it as it moves forward.
Or is there anything else you're watching for when it comes to rulemaking related to that, Malinda?
No, but I'm sure there'll be a lawsuit about it, and then we'll deal with it then.
Fair enough. I have another question that's we didn't talk about prior in our planning discussion for today, but Sam mentioned the benefits that the EPA proposal on methane should yield a $4.5 billion benefit in climate. And I think this is something that people have been struggling with, is how we define benefit. So Sam, in your research and kind of looking at what that means, do you have anything that could maybe enlighten us on how the federal agencies are going to quantify those benefits?
Not really, because I'd be nervous about figuring it out. I mean, you have obviously the CBO that sort of quantifies benefits on the federal side when they do that, but a lot of us who've been dealing with that for too long aren't going to trust that. So how the government's going to ultimately do that, I'd probably turn to Phil.
Yeah, the difficulty comes whenever, so in NEPA analysis, we don't have to do cost benefit analysis. Again, NEPA is a procedural statute. It doesn't mandate a particular outcome. So many NEPA documents, if you go in and look at them, they will have what's called a socioeconomic impact analysis. That will say, here's how a particular decision would change socioeconomic conditions in a particular location. Whenever BLM tries to get into doing cost benefit analysis at the project specific level, it gets really messy really fast. And so we have gone back and forth with the social cost of carbon metric. Is everybody familiar with that? It's essentially, it takes a quantity of greenhouse gas emissions and assigns a social cost based on the impacts from those emissions related to a changing climate. And there are formulas that have been put together, and it applies certain discount rates. BLM in litigation was very successful at defending not using it. There's only a couple cases where courts said you had to use it. And even Judge Morris up in Great Falls, Montana, when BLM explained why we're not doing a social cost of carbon analysis, he said that's okay. But whenever BLM tries to, the one court case in Colorado that was significant, BLM included a social cost of carbon estimate in a draft, took it out in the final EIS, said it's too complicated, but still linked all the benefits in the socioeconomic impact analysis. And the Judge Jackson in Colorado District Court said, no, you can't put your thumb on one side of the scale like that. So I think if we look at what the benefits are of this, it's probably going to be at a very high level and not at particular project levels, because BLM tends to shy away from that in NEPA.
And then a last question before we move to questions from the audience. So audience, be ready, because it's coming to you next, the mic. But with Phil's presentation, we talked about the energy needs of crypto mining. And as I mentioned, I serve in Laramie County, and I remember the first time I heard the statistic that the largest energy consumers in Laramie County are data centers, one in particular that I'm more familiar with. But as I heard this information, it was during Cheyenne Frontier Days, and I was at a concert and I saw everybody had their phone up recording the concert. And all I could think was how much data that uses, because that information is bouncing up to the cloud and stored in a cloud, and just the demands of that. So it just makes me wonder, a lot of the discussion we've had from litigation to policymaking comes on the supply side of energy, but not so much on the demand. Do you think there's an area or a space where we should be focusing more on the demand side of this equation?
I started my career working for a public electric utility in central and eastern Pennsylvania. And every few years, the marketing department would switch over to the conservation department. And it would all depend on what units had come online and what they had. And so it's two sides of the same thing. We have this, do we limit the demand side or do we increase the supply side? And I think as things move forward, we all have super powerful computers in our pockets now that nobody had 15 years ago. And your example is we're sending all this data around and we think, well, there's no cost to that. It's all coming from somewhere else. But I do think that as societies become more complex, energy demands will only increase. So we've got to figure out how, and we can certainly say we want to be as efficient as possible, and we've done that. But those demands are always going to be there because there's somebody going to figure out something Remember, in 2009, there were no cryptocurrencies. And all of a sudden, somebody figured out something, and the next thing you know, you have certain countries that have banned cryptocurrency mining because of its energy draw. So I don't know what the right answer is, but it's a really important one to think about.
Yeah, and I guess I would just add, I mean, take a look at and think about what some cities, particularly in the West, far West, are doing with respect to natural gas bans. So they're looking at demand side. So they're trying to basically curtail demand of natural gas. You're seeing efforts to try to change efficiency standards of appliances that would reduce the demand for certain things. So DOE is doing that. You're talking about, how we're going to treat heat pumps, all those types of things. You could also take a look at what we've done in terms of the supply chain. President Biden issued an order directing all federal agencies to try to look at supply chain issues for the new effectively green energy economy, if you will. And what that really also emphasized then in terms of the demand side is to take a look at renewables. I mean, not recyclables, in order to really offset increasing demand using more recyclable material. So I think that what we've already concluded as a society is we don't want to change the way we live. So we have to take a look at alternatives for particular types of resources. And so not changing what we're doing, but maybe shifting from one resource to another. And that's really on the demand side.
I don't have any thoughts on the kind of demand side controls. I do know that a lot of these decisions from the courts have required BLM at least to analyze what those, we call them downstream, what those demand effects are. So not only what it takes to pull oil and gas out of the ground, but also what the greenhouse gas effects of, those end uses are, which is frankly a lot of guesswork, but that burden is already on the agencies to be determining what that demand will be.
All righty. So tell your kids the carbon footprint of that TikTok video. Is it worth it? With that, I don't know. We're going to get questions from the audience. I don't see anyone walking around with a microphone. So unless Temple, yep. Perfect. Oh, there's one back there. So we'd love to have some questions from the audience. So don't be shy. Raise your hand and we'll get a microphone to you. And please just introduce yourself, your name and the organization you're with. That'd be great.
And Affie, if I could just add, people on Zoom, please ask questions as well, and I'll walk back over and check the Q&A function on Zoom. All right, Brian Ennis in the back.
I think this is more for Phil, and I know BLM is doing its own rulemaking and looking at the crypto use on lease. Is Honor also? I'd imagine once you determine that it is a royalty that has to be paid, the question is, how do you calculate that royalty if you're charging less than what you would, I guess, get in the market downstream?
Yes, I can say, so BLM is not actively engaged in a rulemaking right now. So normally you get what's a NOPR. We all live in a world of acronyms, right? Notice of proposed rulemaking, which you can, for the people who love to figure out those formulas in the Federal Register whenever they come up, you can look for those, and that will give you the first thing. The unified agenda also does that. It says, here's the things the administration is going to work on with rulemakings. Right now, cryptocurrency is not on there, but I can say that there are active investigations that are going on now to look at where this is taking place, how it's taking place, and whether the reporting and record keeping requirements for the lessees are being complied with. So Honor is involved. I can say that. Yes.
We have about 9 minutes and we see a hand right there. Thanks, Pete.
Good morning, Pete Obermueller with the Petroleum Association of Wyoming. So it's my understanding, and probably for Malinda and maybe Phil, correct me if I'm wrong on this understanding, and it'll be a short answer. But if I'm right, I would like to know sort of the authority for this. It's my understanding that the BLM has not actually issued a lease in Wyoming dating all the way back to the Q4 of 2020. They have they've purchased leases, but they have not issued one. And what I'm curious to know is there any sort of directive? Is there any sort of authority to not issue leases once they've been auctioned and purchased? And or any sort of shot clock or timeline or anything like that? Or is it just whenever they get around to it?
Pete, it's not whenever we get, and I have a table full of BLM experts that I'd love to put on the spot, but I'm gonna get your last part of the question first. So we had a case with Western Energy Alliance in district court in Wyoming a number of years ago that looked at some changes in lease policy where BLM is obligated to issue the lease within 60 days after it's been sold, or it can let the lessee know that there is going to be some delay in issuing that lease because of some procedural issue that needs to be dealt with, like remedial NEPA when a court says you didn't analyze this well enough. So it gives the lessee the option to either wait for that work to be done or to get their lease issued. But there is a timeline, it's 60 days, but it's 60 days to make to let the lessee know we can either issue or you're going to have to wait. The first part of your question, from the June sale, I believe that we've issued all of those leases. You may recall that there were 2 environmental groups filed suit the very day of the lease sale. And all of those leases were issued, but right now, lessees need to be aware that there's a cloud over those leases, that they've been challenged and we don't know how that's going to work out. And so if the lessee said, I'd like to have my lease suspended until this litigation works out, then BLM would act on a suspension request, right, like that. But June 2022 lease sales from Wyoming have been issued. And as long as Dwayne Spencer nods and Andrew agrees, then I'm okay. So.
I think have the December 2020 ones been issued? No, yep. And those are impacted by at least I have a chart where I keep track of what lease sales in what litigation, which I don't have in front of me, but I know those are in the Montana Wildlife Federation leases as well.
Right. And yes, and those haven't been, and that's because of the way that litigation worked in phases. So I hope that answers you, Pete, somewhat.
Hi, thank you all for your remarks. My name is Eric Wackerlin. I'm an attorney with Brownstein in Denver and Cheyenne. This question is for Professor Kalen. You mentioned the recent decision in Louisiana for the LNG facility where the staff of FERC, I believe you said, found that they couldn't overcome the environmental justice concerns. And it sounds like you've done a lot of research on and work a lot in this space. And it comes up in my practice a lot. And I guess my question is, there's a lot of focus on kind of cumulative impacts in the NEPA world and in the environmental justice world, and kind of a lot of different places. Curious in that specific case, and then more broadly, whether they factored in any consideration of kind of downstream benefits of the LNG, and maybe how that fits into energy poverty issues and arguably some, environmental justice kind of cumulative, I wouldn't call them impacts, but benefits provided by the resource. Because what I'm seeing a lot of times, and EPA just issued an FAQ on environmental justice, is kind of not looking at benefits that might be associated with the resource at issue, and just looking at, environmental justice impacts from pollution or construction of the project, things like that. So curious your thoughts on that topic.
Yeah, thanks. First, it wasn't a decision. What it was is it's a staff effectively recommendation to the commission. And it's the first time that the staff in an EIS is recommending to the commission that we can't overcome these environmental justice issues, because cumulatively, this particular LNG project with all the other facilities in the Gulf are going to cause an adverse or disproportionate impact to low income or minority populations, particularly the local fishermen. And so, so that's the status, and we don't know whether it'll be accepted or not. But in the context of the cumulative impacts as they relate to EJ communities, I mean, I think that part of the difficulty is even judges have no clue how to really understand cumulative impacts. And that's because it's sort of, I don't want to say philosophical, but it is a very much more of not an easily understandable legal concept. And even the 1996 CEQ guidance doesn't really help a lot. So it's typically now very difficult to understand how we look at cumulative impacts. But aside from that, when you're talking about benefits, looking at the cumulative benefits, I mean, the EIS is not typically designed, as Phil explained, to really do any kind of cost benefit analysis. So it's really not out there as a document to help the agency understand we should do this document or do this decision because it's going to add an extra $3 million of benefits to the local community. But with that said, other aspects of the agency decision-making outside of NEPA might typically take a look at that. So for example, in a record of decision, they might actually look at what the cumulative beneficial impacts would be to a community, as BLM could even do that in terms of outside of NEPA, why they think that getting an extra, let's say an offshore oil and gas lease is going to add to the US Treasury of X amount of money. So I hope that answers it.
We have one question from Zoom. So we talked earlier, the panel talked about the pendulum swing between administrations. And so the question asked, based on the energy supply demand discussion, can you further elaborate on what you see as a balanced approach moving forward between regulator, developer, and the public, including an emphasis on environmental justice priorities and climate change? So it's a bit of a philosophical question to end on.
I don't have a philosophical answer, but I will note the BLM compiles really great statistics on their oil and gas leasing program with charts. And it's actually really enlightening to look at what you predict each administration will have in terms of offering the number of lease sales, the number of outstanding leases, doesn't necessarily correlate with what you think it would versus, with the ways the administration goes on that. So I've always found that a very interesting resource to look at, just what different administrations have done in terms of oil and gas leasing and permitting and all of that.
And I'd just add, again, remembering my disclaimer, from a philosophical perspective, we heard this morning from the governor and the deputy secretary. We talked about Wyoming being an all of the above state, and it really is, but it's how do we make all of the above really work? And part of it's engagement. And there are certain groups you can engage the groups and explain, here's why we're doing what we're doing, where we're doing. And hopefully you get some kind of consensus as a community that this is worth it. Because the difficulty comes when you have courts in other states deciding what's going to happen in your state. And that's where and again, just think of my disclaimer, because I'll get fired well, my boss is over there. She's okay with it. It's something that we have to make a societal decision. Do we want to have these energy sources? Do we want to have relatively inexpensive fuels for our cars? Do we want to have a robust energy infrastructure? And we can't answer those questions here. I mean, that's a bigger societal question, I think, on the strictly philosophically speaking.
Saved by the bell. It is lunchtime. Thank you, panelists, for your wisdom and thoughts, and Temple, thank you for having us.
Thank you guys.